Municipal Council. Technically, it's a board meeting. It's been publicly noticed. It was originally, it's actually really a meeting of the zoning committee, but since we have more than 3 council members who wanted to participate, we felt it should be publicly noticed. Time is 10:06 a.m. We're meeting in the City Center conference room. And let's begin with the roll call.
Marcus Draper, Assistant City Attorney.
Brian Jones. Cliff Stratton.
David Harding.
Elizabeth Hamilton.
Dave Sewell.
Dave Connect.
Kelsey Zarkov.
Gary Winterton.
George Handley.
Gary McGinn.
Harry Walls.
Thank you.
Is it officially, Kim, are you not here with us? I don't know. What,
I was done at noon on Monday, so.
is that what it was? I didn't know.
Yeah. I'm officially here with you, but not.
Hey, thank you. I just want to hear your name again here.
Oh, thank you.
And we'd like to welcome Councilmember George Stewart, who has just joined us. We have someone assigned to give a prayer, please.
Our Father in heaven, we give thanks today for the opportunity to serve the people of Provo. We're grateful for the freedoms we enjoy and the ability we have to choose our leaders and to seek after solutions that benefit our community. We pray that today, as we talk about zoning issues, that thy Spirit will pervade us and provide us with inspiration to address and overcome our differences and make good policy for the people of this community. And we say these things in the name of Jesus Christ. Amen.
Thank you. Just wanted to make a few comments before we begin, and then I thought I would turn the time over to the zoning committee to conduct the meeting, but there's a couple of things we want to accomplish here. One of them is there are a number of council members who have some revisions that they would like to suggest. We want to make sure that that all the council members who have proposals have time to present those, and then what I'm looking for is a recommendation from the zoning committee by the time that we finish the meeting, and at this point, 2 remaining members of the committee, as to which, if any, of these proposals that the zoning committee is willing to endorse. So it could be kind of a, yes, we're on board with that. Let's go ahead and incorporate the suggestion into the draft and have it ready for January 9th. Or we're not sure yet, we think there's more discussion needed, or if you're certain that you don't want to support it, then that would be the other possibility. So I have 6 specific suggestions for amendments, or I guess I call them amendment concepts. They're not really fleshed out into detail, but I'd like to present. I would suggest that we limit discussion on each of those to no more than 10 minutes. I'm not sure how much time you have reserved for this first item, but we want to make sure we have plenty of time to discuss the potential revisions. And Councilmember Harding has a more concrete proposal that incorporates many of the concepts that I will discuss. And then I'm not sure if Councilmember Winterton or Handley have any additional suggestions that aren't covered. We would, of course, welcome your thoughts as well. So that's kind of what I'm envisioning for that part of the meeting. Do we have a member of the zoning committee that would like to conduct it from here?
Well, I'll take that role for the moment. To me, this is awkward because we don't have a chair of the committee, which would be necessary to have this formal committee meeting. And we also need an oversight failed to have a vice chair selected, so we are without leadership. And because of that, I'm more than happy to lead a discussion as kind of the vice chair of the council and talk about this issue. And I did want to clarify that the makeup of the zoning committee was 6 members, as I saw it, as we advertised, as we met, and as we discussed and voted on these things. And not just the council members. And because we really don't have a chair to lead a formal committee meeting, and because we don't do committee meetings in this kind of an open format, I'd just like to proceed and lead the discussion as the vice chair. And I would like to bring you up to speed if you weren't aware that the last recommendation of the committee meeting was to change nothing in the ordinance at this time, but to go ahead and implement it at the discretion of the administration. That frankly, they have a lot of discretion on how and when they do things. And then we also, some two committee members, Kim and I, sought the opinion of former City Attorney Neil Lindberg, who worked for Provo many years, has a wealth of experience, and we thought it would just be a fresh, neutral opinion, and his opinion came back basically saying that we ought to give it a shot and see how it goes, to know how to tweak it. Since nothing's perfect, it's like making a cake. You think you have a good recipe, so try it, and maybe you need more salt later. But that being said, I understand that there are proposals, you and Dave, and there are questions of timing. So we need to address those. I would just like to add the administration has great leeway. They asked for a tool, and we gave them that tool, and how and when they use that tool is at their discretion. However, if the council chooses to further clarify to the administration, for example, when this law should go into effect, then we can try and reach consensus on that or other issues. So I think that's the purpose of today's meeting, is to try to see if there is a consensus on anything. And did you want to add anything, George?
Oh, you said everything I would say.
Same. So do you have a preference who goes first in presenting proposals?
I would like to go first, if that's all right. With some more general concepts. And
Do you have an analog copy of those? I didn't print them off.
we could print them if you would like. So the documents that Mr. Stewart has requested. First of all, let's bring up the one that's on SIRE that has the 4 principles and then the 6 concepts. It's the third one down, rental disclosure ordinance amendments. So that would be one. And there's a couple other related documents to that, but I'll start with this one. So as I see it, there are 4 main goals that I think we should be aiming for with this ordinance and with related ordinances that may be coming in the future. The first one is compliance, and part of that would be to improve respect for and voluntary compliance with our zoning laws. And I think that should be the overarching goal. The second one, which I think has been more of a focus of the committee so far, is to improve zoning enforcement effectiveness and efficiency. And I think that's very important, and this proposal has been good at achieving that, but that's really sort of a means to an end, and that number 1 is really the most important of all of them. Related as number 3 is to minimize the regulatory burdens that the ordinances impose without compromising effectiveness. effectiveness, enforcement. And then the fourth one I think is important as well, is what's the overall message we're sending to the city and to our residents with the ordinance and with the way it's being proposed. I think we need to keep that in mind as we're working on it. So with that as a backdrop for my interpretation of what the goal should be, let's dive into the proposals. Proposal number one has to do with clarity. The current ordinance, read it.
Can I just make a comment on
Sure.
compliance?
Sure.
Interestingly enough, it's been our first priority and compliance hasn't increased. It's just like with children, and I have a lot of them. When there's no penalty for your actions, and particularly if there's a financial incentive in this case, people don't comply because it doesn't pay them to comply. So I see that I would love compliance to be the first principle. Unfortunately, compliance hasn't occurred without some kind of enforcement better than we have today. The whole purpose of the committee was to increase the enforcement. If you don't increase the enforcement in a substantial way, compliance is going to occur. The citizens have always shown that those out of compliance, and most people know they're out of compliance. I mean, to think that they don't know, I think is not reasonable. They know they're out of compliance. That's why they've been fighting this ordinance so hard. And if there's no penalty, there's no compliance. No different than with children, anything else. When you know there's a speed trap, why?
I would agree with that. Enforcement is definitely a very, very important part of the overall picture. If you have a speed limit sign and it's never enforced, then you're not going to get as much compliance. I guess my main point is that's not the whole picture, though. We want to, I think I've already made my point on that. So let's go, Mr. Hardy.
You say let's go. Give me 30 seconds.
Okay.
I agree. We need to have enforcement. If we're going to have laws, we need to have enforcement. I think there's a lot of things that go into whether people choose to comply or not. And I think one, understanding, knowing what the law is part of it. I've received emails, past years where people have bought, being told one thing by their agent that they can do certain things, and then it's not until they start to try to make some changes to their properties that they're informed, oh, actually, that's not, so I think just that being informed and knowing what the laws are is part of it. We talked about speed limits. If there's a speed limit on the freeway and it's 65, and even if you don't see, an officer enforcing right then, but if everyone's driving 65, you kind of stand out if you're the one person doing 80. But if everyone on the freeway is doing 80, you don't stand out if you're also doing 80. You don't have that kind of that social expectation that the speed limit should be followed. And I think we're at the point right now where there's no social expectation that our zoning laws are going to be followed. And I think we need to change that, and I think enforcement's going to be part of that. But I think if there's other ways where we can improve respect for the law, and there's stories that people have called up the city, and the city has told them, whether it's true or not, but the story is that they call up and say, hey, can I do this? And they say, well, technically no, but we don't enforce anyways. We don't care. Go ahead and do it. And if that's stories that we pass around, kind of the culture is, it doesn't matter. Compliance doesn't matter. And we need to get to the point where people know what the law is and they're choosing to follow the law. And part of that may be fear of enforcement. But if that's the only thing that's pushing them in that direction, I think it's difficult. I think we'll get better compliance if we change all of the.
I certainly don't think that's the only thing, but I think the major reason people don't comply, don't want to comply, is because they don't get enforced on. And we haven't had the tools. The whole purpose of the committee was to provide the tools to enforcement arm of community development so they could. People really knew that we were going to do it. And I think we sent a full message when we say, well, we're going to do it, but let's put it off for a while. Anyway.
All right, so point number one has to do with clarity. The current ordinance redefines the word contract in a way that I have seen has caused much confusion. And I've got a little diagram that kind of illustrates this. Kelsey, could we pull up the one that's titled B1 versus B2 versus B3? Part of the artwork, that was never my forte, but so the labeling here, RC stands for rental or lease contract, WRC stands for written rental contract, VRC stands for verbal rental contract, and any rental situation, there is a contract that's either written or verbal. And DA stands for the disclosure and acknowledgement documents that the current ordinance is requiring. So in the original version 1 version of the ordinance that I don't think ever made it out of the committee, the proposal was to require all landlords and tenants to have a written contract and for the disclosure and acknowledgement to be part of that. The current version that was passed, there's three options. There's still that option to have the disclosure and acknowledgement as part of the contract, and now if you scroll up a little bit, the other two options are you can have the disclosure and acknowledgement as a separate set of documents that aren't part of the written contract. Then the third option, if you scroll up a little bit more, is you don't have to have a written contract. You can still have a verbal contract, and the disclosure and acknowledgement documents can be separate from that, obviously. So the problem I have with the current wording is, let me back up, go up into the top. So version 3 is just what I call the draft that Mr. Jones prepared at one point that changed the wording such that the disclosure and acknowledgement documents were actually called disclosure and acknowledgement documents in the draft, and the word contract was not redefined. So as I compare these two, and you can weigh in, Mr. Jones, if I'm not stating this accurately, but I saw no difference between the two drafts in terms of practical effect, in terms of enforcement. To me, the only difference was what you called the documents. Is that accurate?
Yes, I would agree. And I guess just to clarify one thing, I'm maybe a little bit confused by in version 2 above your circle that says WRC and VRC, what the question mark not contract quotation means.
What occurred to me recently is technically, according to the way the contract is defined, a written rental contract, if it doesn't include the disclosures and acknowledgement, doesn't meet the definition of contract.
I see what you're saying. Yes.
So,
okay.
It's kind of weird because
you don't have, if you have a contract that does not meet all the requirements of the ordinance, you don't have a contract for the purposes of the ordinance.
For the purposes of the ordinance.
That's accurate. Okay.
Yeah, and so it's caused a lot of confusion because whenever you use the word contract, you know, it's like you have to specify, are we talking about the quote unquote real contract, the real rental contract, or are we talking about the pseudo contract or whatever you want to call it, that according to the way the ordinance defines it. So the most general misinterpretation I've seen is that a lot of people who have looked at the ordinance or have heard the discussion think that we're still at version 1. Think that we are still requiring written rental contracts between all landlords and all tenants. And so I've seen complaints about you're doing away with verbal contracts, which is not accurate. You're doing away with subleasing agreements, which is not accurate. And to me, it's just caused unnecessary confusion and in some cases opposition because of the misunderstanding. And I think if we just call a spade and come up with a term for the disclosure and acknowledgement documents that doesn't involve redefining a word that everyone already knows what it means, I just think it would be a lot clearer. So anyway, that's the concept for that one. how does the zoning committee feel about entertaining, heading in the direction of something similar to what Mr. Jones had originally proposed? Doesn't have to be that exact wording, but that doesn't involve redefining the word contract.
So this is where I think there's a lot of leeway with the administration to clarify what is often laws that are written from lawyer to lawyer, or and it's written so lawyers understand it, and it's clear in the courtroom. Version 2 is clear and enforceable and clear to the lawyer. It's not clear to the public, perhaps. So what the administration can do is they can say, hey, we have a new law, and they just issue a statement. The public normally never goes back and reads our ordinance. They read what is given to explain things. If they read our ordinance, they would know that in Provo, it still says that a family is 2 singles, because we haven't changed it in 10 years in those 14 neighborhoods. So we need to put out clear information to the public, and if that clear information says in letters to the public and the landlords, hey, you can satisfy it by giving us a contract that has this information, a standard contract, with the disclosure and acknowledgements, or you can just give us the disclosure and acknowledgement, and we don't necessarily have to see the written contract, and obviously, if there's a verbal one, we can't see it. So giving that name to the document can be done by the administration. And so the clarity can be achieved, in my opinion, by the administration and informing the public what is wanted. Of course, we can change the ordinance, but I'm just saying, pointing out that I believe that the administration can achieve the same purpose by just educating the public.
I agree with what they're saying here. My whole concept here is, I believe that we just need to make it more simple. We need to get it on a one sheet. I've spent a lot of time, I spent time with Gary, and I'd like to just talk about, let's do one sheet. There are a million contracts. And I agree with that. I would like to just have the city have the 3 things on a specific thing that they can.
Gary, just know, I'm in favor of that also. I think Dave's in favor of that also.
Well, with one caveat, that if you want to do it on one sheet, what I would recommend is that the administration prepare, when they send out new, I don't know, when they renew every year, do you send out a new acceptance letter or any paperwork, or do you just do it electronically?
It's just electronically.
But so you can do it so that they click it and it won't allow you to get your license.
But if this coming year, when people renew, you send out a document, and the document is a copy on one side of their rental dwelling acceptance letter, giving the occupancy, giving the parking, and on the flip side, it's the tenant's rights, and on the bottom, it's the disclosure where you can both sign. And then you have a one-page document from the city with everything on it. But I'm reluctant to say that we're going to have a one-page document that doesn't require you to actually show your rental dwelling license approval letter, or the fact that you actually have a rental dwelling license. If all you have to fill in is a couple of boxes and say, well, this is the parking, this is the occupancy, and not show anybody your copy of the rental dwelling license.
That's not what the agreement says. The agreement says that I have a contract.
Yes, but that's a contract between the owner and the person leasing or whatever. But I'm saying someone could enter into a contract with an owner and never realize that owner didn't actually have a legal RDL. And there are quite a few people in town that don't have RDLs, but they could satisfy the requirements of the law by saying, here's this disclosure, and the person renting would have no clue that the
disclosure says I give it to my tenants.
That's correct, but it doesn't say that I have a rental dwelling license and it's with the city. We have a lot of landlords that do not have rental dwelling license.
Why could that be made part of the one page?
Well, it would be if you had on one side their actual acceptance letter proving that they had a rental dwelling license, and on the other information.
In my conversation with Gary, my understanding would be that was what we would have. We would have something that really forced people to be able to disclose what their occupancy limits and parking limits are.
Well, yeah, but it's one thing to say, these are the numbers, it's another actually produce the document that.
Let's make that document part of what we have. Is that possible?
Yeah, it is.
It's possible.
Right, and that's what I'm saying, it's possible on the administrative level to have that, but I don't want it to be done in a way that they can get away with actually not having a real RDL.
We direct the administrative level to ensure it's there. And we're okay?
As long as we are all on the same page.
Yeah, and this idea of a one-page came up after the ordinance was passed and through lots of discussions. If the desire of the council is to make sure that when someone rents out, they let them know their rights and responsibilities. I mean, the landlord lets the renter know the rights and responsibilities. They disclose to them what the occupancy and parking is, and that they have a license and what that license number is, or a copy of it, or whatever that would be. We could work up a draft of something that would be a one-page thing. It'd probably be both sides of it, of the paper, that an ordinance could say, okay, landlord, you have to give this document to your tenant.
That's my proposal. I mean, I agree with Gary. It'd be nice to be more simple. So why not just direct you to do that, and then we at least solve that issue. We don't have to discuss that one issue anymore today, because that's been a big issue. It's not simple enough. Well, let's make it simple enough and enforceable, and do what we thought it was going to do.
And then one thing that it could do is when we have that form, they have to give that form. And then when we ask for it, we say, where's that form? And we just see that form, and we don't have to thumb through a contract or any other thing to find it. It'll take a little bit of work to get the right form to make sure it's user-friendly and usable. And we'll have to figure out how people can get the appropriate information in it. And we would come back and show you what we would have and how we would do it. And it could be something that frankly, with 360 will be our new software project, Provo 360, and some GIS stuff that we've talked about before. People could actually go on to a property and on our website and see if it has a rental license and see the documents that they need to have.
At least the council in agreement, that would be good. Anyone objecting to that?
Well, so just to clarify, so when I talked about this with you, Gary, you mentioned there were two pieces of information in the RDL approval of it, that the occupancy limit and the parking requirements. And my understanding was that what we talked about is you just put those two pieces of information rather than reproduce the whole letter.
Well, we could,
Yeah.
but if there's a desire for the council to have the actual letter, or then that would be harder to do, but we could figure out a way. We'd have to sit down and think about it. I think there's a way to do it. Off the top of my head, I don't know the easiest and best way. There's also ability, you could disclose maybe not the actual letter, but here's my bar number, 06769, right there. I just gave you my bar licensing as an attorney number. And you have that, and you could call the bar and say 06769, and they could give you all the information on me. And we could do something like that.
That's
where
not reasonable, Gary.
what?
Why would you ask people to have to make a phone call to somebody? Why would you put it on the floor?
Well, I'm saying you could. I'm just saying there's different variations
No,
of.
let's be practical though. You wouldn't want people to have to make a phone call. We're trying to make this more simple.
No, for the point that they have an actual license to show that they, they could give their number, they could give.
License, the best way to show they have a license is to show they have a license.
Yeah.
Right?
And we could figure out a way to do that.
Thank you.
Right, so we jumped into, item number 2 on my list was the discussion of the 1 page. So it sounds like there's some interest on the zoning committee to pursue that. Maybe some opinion as to how that would exactly work, but it seems like there's interest in minimizing the paperwork at least. We could just go back really quick to this first item here. So am I gathering that there's not an interest on zoning committee members to pursue what I would call less ambiguous language?
Yes, Dave.
Yes.
Just ask, I wonder if it would make sense to go through all of these and maybe even the proposal that I wanted to discuss. And then at the end, just have time for zoning committee members to discuss and decide maybe then kind of, once they've seen all of the different proposals, what they're, rather than kind of go through each one and everyone would just love this or this.
But with that, Dave, it's really hard to go back and try to hit everything that you want. For me, it's easier as you go on, we can discuss it. Okay.
Dave, I'd be just interested to hear from Dave and George about what's at stake in your minds with changing the word contract. I mean, what happens if what I heard you saying is if we could sort of, in effect, clarify it in another way, but I'm wondering if what you feel is at stake if we change the wording in the ordinance right now.
Can we bring up the draft that actually shows that? So we can see what we're talking about. The one that ends in B3, the document that ends in B3. No. I think it's the second from the bottom. This was the language that was originally proposed by Mr. Jones.
Right, so part of it is messaging. And one could argue that this would create just as much confusion as the other one. Well, because people would say, what's this new thing called a disclosure and acknowledgement? You're trying to introduce a new lexicon into the rental contract world, where people have contracts and leases that they don't have disclosures and acknowledgements. I've never heard of it. Now, if you say this, Dave and I went to lunch and talked about this, and whether you try to modify version 2 to be more friendly, or you try to look at version 3 and say, well, how can we come to some agreement? Disclosure and acknowledgement of a contract would be another way to title this. I would not remove contract from the title, because what you're acknowledging is that you have a lease, you have a contract. So if you want to be crystal clear, then you leave the contract in there, because we are requiring contracts and leases. And we are requiring.
No, we're not, Dave. A verbal, but if you're saying it's a verbal, but we're not requiring
I'm not saying written. I'm saying if you're acknowledging that you have a lease for that property, whether it be verbal or written, then you have a lease, you have a contract.
Right. And so, again, there goes the confusion of what's a contract. Is it verbal, if it's written?
Yeah, well,
I get that.
but in the legal sense, whether you have a verbal or written, it's not going to matter. You have a contract.
Right, I agree. But you can't show a verbal contract.
But you can show the acknowledgement of that verbal contract. You're signing that I have a contract.
And that's the one-page document that I'm.
Yes.
Yeah.
Yes. So that one-page document, and the most important part of it is where you sign on the dotted line that I am leasing, I have a contract, whether it be verbal or written. And then down on this, contract means or disclosure and acknowledgement means, my preference was that you just say it can be A or B. You can have a contract that includes the following information, or a standard contract, that is, or you can have a disclosure and acknowledgement document that includes the following information. So you can satisfy the law as you saw in the diagram 2 different ways. And, you know, whether we go back in and change it to make it crystal clear in the ordinance that it's A or B, or whether the administration makes it crystal clear that contract means at a minimum. At a maximum, it means maybe you can provide the real thing, the contract with the extra material, but as a minimum, you have to supply the extra material.
Okay.
Well, a question back on the previous one. Does the council want a one-page document that has their license, the acknowledgement, tenants' rights and disclosure, and a little statement that I acknowledge that I'm leasing out the property?
Why not?
Okay, well, because if you have that, then that's all I need. I don't, if that's what the council wants, then I only need to get from people that one-page document.
Right.
And if we're creating it, they're gonna have it.
In that one-page document, and I'm sorry, I'm, really struggling to get up to speed on this, but that one-page document does not have to be called a contract, or if it were called a contract, it could be confusing, potentially.
Yeah, we could call it whatever we want. It could be a contract. We could define it as a contract. We could call it an acknowledgement and disclosure and define it as that. We could call it a rose by any other name, smells as sweet. And so I guess what I'm trying to find out, do you want multiple ways for people to comply with it, or one way? Here's the one contract, that's it. I don't care if you have a verbal contract. Well, it's easier just to get one piece of paper.
That's what I think.
Here's a standard piece of paper. You have to use this document.
Here's the thing, Gary. When you enter into a contract these days, someone says, hey, can I see your contract? Well, okay, I go get my papers. Now, if with those papers, I have been given, maybe stapled on there, or maybe the landlord has even made a custom contract that somehow has this in there. But if it's attached to a contract, then it's with your contract. And yes, you can pull it out separate. We don't necessarily have to see the rest of the contract. We can make that clear that it becomes part of the contract, generally speaking, when you enter into an agreement with the landlord, because you're going to have to sign that as part of entering into that contract.
Yeah, and if you have a one-page thing, whatever we call it, that's what we're going to ask for.
That's what I'm in favor of.
Yeah, and that's all we would ever ask for, because they might have a verbal agreement, they might have a written agreement, they might have a written agreement with lots of separate documents in it. But I thought what the council wanted was a simple one-page piece of paper and we would generate it, and it would be a city-produced document.
Provo City on the top of it.
Yeah, but whatever we call it, and then the landlord by ordinance has to use this document.
Why can't we use that? If that's the direction we're going in with a one-page document, why can't we call it what it is? Give it a name and put it in the ordinance that that's what's being required.
What would be a good name from your standpoint? I mean, if we're concerned,
One-page document that you have to use and.
Provo City, the Provo City rental disclosure document.
Yeah. Something like that. Because if there's several ways to satisfy the ordinance, then the effectiveness of the one page kind of goes away, because if I ask for the one page and they don't give it to me, they still may be in compliance. I have to, really, okay, all right, there's this new ordinance and there's several ways to come into compliance, and you can do it this way or you can do it, as opposed to, hey, here's a blank copy. This is what it looks like. When you signed your lease, the landlord needed to give you this, and they had to sign it, and you had to sign it. I need a copy of that. And each enforcement officer would just take it with them. And whether you call it a contract, whether you call it acknowledgement or disclosure, that would probably, once we get the form done and figure out how to do all that, as enforcement day to day, that's going to be easy.
Right, so at the door, you may have to explain to them when you say, hey, do you have your disclosure and acknowledgement agreement? They'll go, what's that? Or
Oh, it looks exactly like this.
right, and they'll go, well, they may even say, where would I find that? Well, it should have been part of your lease contract. When you signed it, you would have been given that.
Well, if they had a signed contract, and some people may not, and that's been one of the problems that people have been talking about. And it's like, did the landlord give you this piece of paper?
What are your feelings, George?
Well, as long as the ordinance requires that they give that to them and that they disclose it to our zoning officer. I actually like it.
Could we go back to the list of the proposed amendments? Okay, so that was number 2. Had a good discussion about that. Can we move on to the next one at this point?
Can I just
Yes.
point out that, I mean, from my perspective, what I think I'm understanding though is that if you are using a one-page document, that one page should have a name.
It should have a name.
And that name ought to be the name that appears in the ordinance.
Exactly.
I like the name
That's what
you
I'm
gave
proposing.
The Provo City Rental Disclosure Agreement or something like that. So,
That would solve my concerns with the ambiguity of the current ordinance. Okay. Civil penalty. So just very briefly on this, I was reminded recently that some time ago, Orem City had an interesting situation where there was an older lady that was refusing to cut her weeds, and there was talk about whether or not she was going to get thrown in jail.
I think this was my neighbor.
It's your neighborhood.
I'm pretty sure it was.
I thought it was in Orem, but maybe.
Well,
There was one in Orem.
there was a prolonged case on Oak Lane.
Well, so for zoning, zoning violations themselves that impact other people directly, with weeds or trash or over occupancy and that, I can see some rationale for a possibility of jail time, although that might be a worthwhile discussion to have in and of itself. But for lack of filing a disclosure, I'm having a hard time thinking that should be considered a crime that could carry a potential of jail time. Now, we say that there's no way we would ever do that if someone didn't sign a disclosure, but if it carries a criminal penalty, that's always a possibility. And in my worst nightmare, I can imagine a conscientious objector who is in complete compliance with all of our zoning regulations, but just doesn't want to sign the disclosure. And are we going to put that person in jail? I sure hope not. And so, to me, it just makes sense to consider going a civil route. You can have pretty steep fines, and civil penalties are more oriented around restitution rather than punishment. And to me, the only real harm in not signing a disclosure is it does cause more work for our zoning enforcement people. And that's a cost to the city. So it just seems like a financial fine would be adequate restitution for that. So that's
Should we change all our zoning violations currently are classing misdemeanors? Are you just saying change all the zoning?
no, I'm not.
So why distinguish this?
In my mind, I see a distinction between zoning violations that impact other residents. Like I said, the parking spillover, trash, weeds, that sort of thing, versus this new requirement that we are only instituting as a way of helping our enforcement people be more efficient. And that is important, and it's valuable, and there does need to be compensation if they don't comply with that. But I just think that a civil fine is sufficient. Carrie, yes.
Dave, the only time that an officer is going to ask for that form is going to be when we suspect that they are in violation in other means, in other ways, perhaps occupancy, perhaps parking, whatever. We're going to verify, we'll use that form to verify whether or not they are in compliance. if they're in compliance with all the other things, then it's not going to be a problem as far as going to take them to court or anything like that. So I don't see this as being an issue. The reality is, as you well know, is we don't put people in jail for zoning issues. And that amount of fine will never get asked for. As far as I know, I think it ends up being $250, and generally first offense is plea in abeyance, which is really just behave yourself for a limited amount of time, and then you can ask to have it dismissed. So I don't see this as a real issue.
Because you're saying you think we would never put somebody in jail, that it is not an issue, or?
I'm saying it wouldn't be an issue because the only time we would be asking for this rental disclosure form is if there is a problem that they would be cited for other issues, not just not having a disclosure. That makes sense?
Yes.
I think there's value in being consistent, and there's some proposals up and whatnot, and I don't think we've worked through all of the details, but for things that are in land use zoning things, I think there's value in being consistent and keeping it as Class C misdemeanor. If we're putting things into the business license portion of our code, I think it would be good to look and see, are most of the requirements there, what's the penalty for that? Loss of license? Or is it misdemeanors?
Class B misdemeanor. It's a Class B misdemeanor to not have a rental dwelling license and to be renting out a property. So there is a criminal aspect to that.
Okay.
So in fact, the one thing we need to recognize here is that by default, violation of every single city ordinance on the book is a Class B misdemeanor. It's only less than a Class B misdemeanor if the city code says that it's less than a Class B misdemeanor. So violation of any city law, not just and again, I get where the proposal is coming from, but it's coming from from my perspective. I think it's coming from a little bit that those who are opposed to the ordinance perceive criminal action as being a stigma. But and maybe Marcus was about to point this out, this may be a kind of an issue of be careful what you ask for, because criminal procedure actually provides more due process than civil procedure does. So if someone's accused of a crime, in order to be fined, they have to be taken in front of the judge and proven beyond a reasonable doubt that they are in fact guilty of the crime before they can be fined anything. Whereas for a civil fine can just be assessed by a city official and the appeal goes to the mayor, and the appeal beyond that, the person actually has to go hire, well, they don't have to hire an attorney, but either hire an attorney or as a pro se litigant, which puts them at a huge disadvantage, go file a lawsuit in district court to try to appeal the fine. And so in many ways, the criminal procedure is actually more protective of the citizen than the civil procedure is. And is the default for all city law violations.
Does that obligate, so a student enters into an apartment agreement, they see a price that they can afford for the month, and they're not thinking very clearly about this. And then the next thing they know, well, maybe they were thinking clearly about it, maybe they weren't. I mean, we have to acknowledge there's going to be all kinds of people on the spectrum, and people who are more aware and people who are less aware. I mean, being around students, I know that they're basically looking at the price, and the neighborhood, which area is this in town? Is this going to be where I want to live? And they're sublease, maybe they're getting it as a sublease agreement from somebody else. But if they get caught in this, and are they going to have a criminal record? I mean, if you are filling out job applications and graduate school applications, have you ever been?
The short answer is no, unless they're a bad actor, because as Carrie just indicated, in all of these cases, we offer a plea in abeyance, which is a way of getting the case dismissed after you come into compliance. It only doesn't get dismissed if you don't come into compliance. And if you didn't come into compliance and you didn't get it dismissed and it got entered in as a conviction onto your record, it's be the same as having a reckless driving conviction on your record.
It'd be less than that.
It's less than a reckless driving. So it's not like having a. Anyway, go ahead, Mark.
I guess just so I can educate you a little bit kind of about how the process of enforcement is currently handled. So currently, if a complaint comes in, we're complaint driven. So we don't have resources to go actively investigate zoning violations. It's all complaint driven. And it's investigated if a violation is found, and this is for anything, but it would include a violation of this ordinance. Then a notice of violation is typically sent to somebody, unless there's extenuating circumstances to circumvent that process, and that's usually for repeat offenders. But notice of violation gives them time to come to compliance. If they come to compliance, it's the end of it. Never even enters the court system at that point. It's a completely administrative thing. Even after the time for notice of violations to come into compliance, there are a lot of situations where people are given more and more time if they're showing progress towards coming into compliance. If for whatever reason there's a particular difficulty in coming to compliance within the 2 weeks granted a notice of violation, a lot of times our enforcement officers will give people more time to come into compliance. If it gets past that point and it's referred to the legal department, then I'll screen the case to determine whether or not there's sufficient evidence to file criminal charges. If there is, then I send a letter to the person saying you have 4 weeks to come into compliance. Here's your drop dead date. And if you don't, you could be charged, and as the ordinance is currently written, with a Class C misdemeanor. And then so they're given an additional 4 weeks after they're sent that letter to come into compliance. And then if they don't come into compliance, we file charges, we summon them into court, and then typically these cases resolve. And the standard deal for somebody who's a first-time offender would be a $250 plain abeyance fee, come into compliance, be cooperative with zoning inspections, be in the conditions, and it'd be typically for a period of 12 months. And all they have to do is pay the fee. They'll be given time to pay that. It's not like you have to pay within 10 days or you're in violation. The judge is going to give them however much time they need to pay that. And then they just have to be in compliance and remain in compliance and cooperate with inspections. Those are the only other terms of the agreement other than, standard conditions. Don't break the law kind of thing. And then after that, they get the case dismissed. So for a person to actually end up with a conviction on their record, they have to really want that conviction. They have to go through what takes months of an administrative process, allowing them to never ever have the case filed, and then go through a long period of time. They have a year to basically square compliance. Standard procedure with Judge Romney in our Justice Court is that even if they violate it and he finds them in violation, usually the first time for a violation, he's going to revoke and reinstate the agreement as the sanction. So it's just essentially extending the length of the plea in abeyance in the terms that they're essentially on a sort of probation, if you will. So if they're going to end with a criminal conviction, they've really, really, really earned it. So is the target always the student, the renter, or because it seems to me I would say it's more often the landlord. It can be the renter if the situation warrants it. In my experience, it's been more often with an over-occupancy situation, the target has been more often the landlord. But that doesn't have to be the case, and it's not always the case.
And two other comments about the procedure is that as far as the situation that you postulated about the student who just doesn't know any better, one of the elements of the ordinance as currently drafted and of criminal law generally that applies even if it's not stated in the ordinance is that in order to be criminally convicted, you have to intend the offense. There's what's called a mens rea requirement. You have to actually know what you're doing. That doesn't necessarily apply in the civil arena, which is another procedural due process advantage for actually the defendants in the criminal arena. The other thing is that one of the first things that happens in any criminal case at the arraignment stage when the person first appears and the judge asks them for a guilty or not guilty plea is if they plead not guilty, the judge will usually turn to the city and say, are you seeking jail time? Because if the city's answer to that question is yes, then the person is entitled to the public defender to represent them in the case.
Assuming they're indigent.
Assuming that they're indigent, assuming that they qualify otherwise. And so, so again, there's a procedural due process safeguard there where the person is either going to be entitled to a public defender to assist them, or again, assuming that their finances meet those qualifications, or the city is going to have already said that there is no possibility of jail time before the case even starts.
May I make just a comment? It seems like to me the purpose, at least in the committee, was to take action against the bad actor landlords. I've never heard us really talk about taking any kind of action against students or any.
I think that's accurate. I mean, that was certainly the discussion that took place in the committee meeting. And I guess the other thing I would add on to that is there is already a way for the city to handle zoning violations administratively or civilly instead of criminally. And the city did that for years and years and found that to be largely ineffective, because what happened is people didn't respond, they didn't take it seriously. We assessed huge amounts of fines and then we never collected any of the fines. And so we turned
You can't. Is it hard? It just.
Well, we would have had to turn them over to a collection agency or hire more people in the finance department to be in charge of the collection. And so
But that's an option for, I think, the committee to take a look at, and that's another tool, perhaps in certain circumstances, it makes more sense when you're trying to get at the financial component of some of these zoning things. And I think that the discussion Marcus and Brian were having is kind of zoning enforcement in general, as opposed to this specific ordinance. This specific ordinance, as passed by the council, only applies to a landlord, but tenant can't be in violation of it.
Well, they can be in violation of not having one. They can't be asked for it.
Yes, we can't ask them for it because
They can also not have ever been given one.
Right, and so
that would not be their fault.
Right, so a tenant could be in violation, but in the way it's currently drafted, in order to prove that a tenant was in violation, what that would require is essentially the landlord coming into court and testifying, I've done everything I possibly could to try to abide by this, and they're hiding from me the fact that this person even exists. It'd be that situation where the tenant would actually be guilty, where the tenants are actually grouping together and they've got a fourth or fifth person in there that they're actively preventing the landlord from even knowing about.
And in that situation, the landlord would be innocent. And so frankly, we think the ordinance ought to be changed so that we could more directly get a tenant, say, who's subleasing out illegally in those situations, because they're in effect acting as a landlord.
Can we jump down a little farther on this list?
Let me just make one more comment. The whole issue of tenant going to jail is a red herring. Never would happen, it never is intended.
And under this ordinance, the remedy is sign this one-page piece of thing.
Can I just interrupt?
Well, point of order.
Yeah.
For Ms. Ellsworth to be recognized, you have to be permission of the chair.
Go ahead, Shannon.
Well, I just wonder how we can distinguish really explicitly in this ordinance who has liability and culpability. Because I appreciate what they've said, that, you know, the tenant would never be liable, but how can we really distinguish that? Is that explicit? And how do we know who is liable in which scenarios? Just so that everyone feels protected.
So in the way the ordinance is currently drafted, it states that a tenant or a landlord could be held liable, but in order to be held liable, you have to satisfy the mens rea component, which requires that they intentionally, knowingly, or recklessly violate the ordinance. And those terms are defined in the Utah State Code and in this ordinance, consistent with the Utah State Code, as to what it means to intentionally do something, recklessly do something, or knowingly do something. So it'd have to be a situation where a tenant, for example, I think the most likely way, I think, as Brian brought up, that a tenant is going to be in violation is through in a subleasing situation where a tenant subleases out to somebody else, but they're, again, they don't tell the owner, they don't, there's disclosure documents are not provided to the sublessee, or they sublease it, intentionally concealing it from the owner, that they're subleasing, or some other situation where these disclosure documents are not being given to the sublessees, and this is a result of the tenant's action as acting as sublessor. That's kind of the most likely situation. There could be other situations, but that
is that ever is that part of the one-page doc? I mean, I'm just thinking of, again,
right.
I
think the one
I say, oh, my friend wants to room with me. I'm going to squeeze him into my room. I was not aware that I mean, if I was just going to split the cost, and again, I mean, I know there could be reckless knowing and intentional violations, but there could be situations where, with a little more education, or because of lack of information about how serious that is, they may not be aware.
Right.
So
I mean, the situation you seem to be describing is a situation where maybe they negligently violate the ordinance, and that would not be something that would be prosecutable.
But that's where the zoning enforcement officers, when they are investigating a complaint, would educate them.
Not only that, the rental dwelling license approval letter states how many people can live in that property specifically. So if a
landlord's provided that already.
If a tenant has already received that and they understand that, then to move somebody in, like, I want my buddy to room with me, well, then he's in violation of that and he would be held responsible.
But you would go through this whole process, give him a chance immediately to rectify that once he's informed.
Correct.
The chance of being convicted of a crime is just right here. It's not going to happen.
And the easiest way to deal with it is for that extra tenant.
Unless they wanted to be convicted. Yeah, they'd have to want to be convicted.
They have to earn it.
Really bad.
I mean, I could envision a scenario of desperation, right, where somebody says, I brought my friend in because they couldn't afford their rent for a couple months and it was just a short-term thing. They knowingly did it.
Right, and in that situation, as I explained, our standard policy is, and I don't see any reason why in the hypothetical that you present why we would deviate from our standard policy, but would be to, if we discover the violation, to give them the notice of violation. If that doesn't work, try to work with them towards compliance and say, look, this is really a financial situation. I signed a contract. I didn't realize what I was doing, that I really couldn't afford this contract. And now I'm just trying to avoid, getting sued by my landlord and getting evicted.
And the other thing is that situation is already illegal and enforceable.
And we would be going after
because that's already just an over-occupancy situation. It doesn't really have it, that particular situation doesn't really have anything to do with this ordinance, which is just about whether they've been given the information or not.
Right.
Okay, could we move on to the next couple here? I want to make sure we have plenty of time for Mr. Hardy's proposal. So we've already touched on the tenant obligation. The current ordinance requires only the landlord to produce the disclosure, although it requires all the tenants to have them. So I sympathize with what Mr. McGinn said. There's some inefficiency there for the enforcement side, and I'm not quite sure I understand.
Can I speak to that really quick?
Yeah, sure.
Because I quite frankly, I will say, as the original drafter of the first two drafts, I think that was just an oversight. Well, it was an oversight stemming out of the amendments, because it was an intentional decision to only, when back in version 1, when we were saying you must have a written contract that spells out all the terms of your lease, it was a conscious decision to only require the landlords to provide that document because it seemed most appropriate for them to be the caretaker of that document. And quite frankly, as the ordinance went through all, subsequent versions where that got changed, we just never revisited the issue.
And I don't think any of us thought about it until after the fact.
But if, as the council seems to already be leaning towards this one-page document, I don't see any reason why we go with that version and there is this one-page document out there that exists, the city is providing. I don't see any reason not to make everybody who's supposed to have one responsible for providing it upon request.
And just as a point, even under the current version of the ordinance, there's absolutely nothing inappropriate about an enforcement officer asking for voluntary consent to provide a document that somebody's not legally obligated to do. And as the ordinance is written, even with the landlord, it requires that reasonable cause before we can require that document. But in a situation where somebody is not going to voluntarily provide it, my advice to community development would certainly be, look, let's not try to force them under the ordinance to do it. Let's just, if we want the document, let's go secure a warrant, which is best practice, regardless. I wouldn't want to rely on somebody's involuntary giving over the document because the ordinance required it. I'd rather rely on a judge saying, yep, you have probable cause, let's go, so you can go seize that document. I think that would be the best practice. And so.
But in that situation, if we went and asked a tenant, do you have this? And they said, no, or I have no idea, or what document I have, or I don't have to talk to you, or whatever it is, we then go to the landlord. Because under the ordinance, the landlord clearly has the obligation to.
Well, I mean, you could do that, certainly. You can, like I said, I think it's perfectly appropriate to ask for voluntary consent. Say, hey, this is the document I'm talking about.
Yeah,
do you have that? Could you give it to us? Or
we would ask for voluntary compliance with that. I don't think we'd ever go and ask a judge for a warrant to make the tenant give it to us when they don't have a legal obligation to give it to us under this ordinance. Under the current version. Right. If the version changed, now that's a different situation.
So here's a question. If it gets to the point where you sent them a letter, this is going to go to court, and when you're going to court, isn't there discovery and you have the right to?
In a criminal case, discovery is a lot different than probably what you're thinking of.
Okay.
Is there discovery? Yes. Under the rules of criminal procedure, a defendant's not actually required to give anything to the prosecution unless a judge orders it specifically, and usually for good cause.
So you'd have to ask.
What I would do in that situation, if I hadn't obtained it before filing charges, is I'd probably just go subpoena from one of the other roommates. I can just issue a subpoena in any open criminal case, and I can go subpoena those documents from people that have them. I wouldn't subpoena it from the defendant. So if I'm charging the landlord, I would just subpoena it from one of the tenants. If I've charged a tenant, I would subpoena it from the landlord. So there are other legal processes that I could use in that situation. But ideally, I would have my ducks in a row before I charged anyone.
If there's one bad actor in the situation, right, somebody else is going to provide it. And in order to get the true bad actor to be the one that faces the liability, not the innocent party facing the liability.
Sure.
Have a solution. What if we put the implementation of this ordinance off to March 1? Would that give the council be happy with these changes we're talking about today and agree on and have an ordinance that's really where we want it? I would go for that.
I very much appreciate delaying implementation until we had a chance to come together more on these things we talked about. I think we all support the goals and intent of the ordinance. It's just.
It sounds like we're really pretty much agreeing on what the new ordinance will look like.
So let's hold on to that. That's after tenant obligation. That's the next one down.
Yeah, the effective date. So there's kind of two components to that. One is the actual effective date of the ordinance, and the other is when a tenant is considered to be out of compliance. To me, it makes more sense to base it on contract renewal. I just feel like we'll have a number of tenants out there that may be subjected to financial hardship. We're saying, well, you've got to produce this disclosure that's going to increase your risk of getting forced on, maybe getting kicked out. I think some people are getting kicked out already as a result of the ordinance. And so what we really want, again, going back to my very first point at the very beginning, what we really want is voluntary compliance. And so if they can see, hey, we're getting more serious about this, and I want to change my situation, I want to come into compliance, just give them the opportunity to do that at the time their contract renews, so they don't have to lose their deposit or last month's rent or whatever. To me, it just, I think we'll get more support and understanding from the people affected. Sure, some people still don't like it, but you know, that's
Sure. I couldn't support that because if I was a smart landlord, I'd renew all my contracts for a year.
Or 5.
well, we could put a time limit on it too.
And that's what I think, to me, the time to do it is,
It just seems to make sense. That's when we have that. That'd be easy, that'd be, I don't know, how about enforcement?
I don't mean to be disrespectful, but then that's taking away any of the teeth that we actually would achieve with this. We, in the past, we used to work with people and, you know, oh, sure, we'll let your over occupancy stay till the end of the semester. Well, then it got to be longer and longer. And in the meantime, the landlord is collecting this rent from these people, and that's no punishment. Already, if we take them to court, it's not much of a punishment to deter them. I do sympathize with the students or the renters, and I certainly think that is something that perhaps they need to pursue if they were not informed that they were more than how many needs to live there, then they have the recourse to sue the property owner or the landlord.
Question, I'm not quite following the discussion and just want to clarify. Are we talking implementation, just the effective date when the ordinance would come into compliance? That's one issue. Another issue is if there is a violation, how long are we giving them to come into compliance?
We're not changing that, are we?
Well, but I think I think there's an enforcement issue here with the proposal to,
Oh, I'm sorry.
well, you're talking about the effective date. But
I'm talking,
about. I think the proposal from Mr. Winston was to have it for any given person not be effective until their license is renewed. And what I don't know from an enforcement perspective how to handle that is if Carrie gets a complaint and she goes out and she talks to the tenants, does she have to look up whether the renewal date for the address before she goes and talks to the tenants?
They're already out of compliance.
Well, that's my question next. If they're already out of compliance, then what are we talking about?
I don't know. Maybe there's nothing to do.
Because if they're already out of compliance, all we're doing is enforcing the laws that are already on the books.
Right, as far as the over occupancy.
When does this new ordinance come into effect and they have to comply with it? Are we doing everybody all at once on one date, or are we going to allow them when they do their renewal?
March 1. It's my proposal.
Sorry.
And that's to.
Time to
iron out.
Thank you.
So one point I'd like to make about if you do it, the effective date simply as different for everybody depending on when their license comes up for renewal. I do think in a criminal case you create due process issues because in order for an ordinance to be valid in a criminal, for somebody prosecute somebody for violating an ordinance, you have to show that it's reasonably clear what is prohibited conduct. And if you're prosecuting a landlord, I suppose in that situation it could be clear because they should know when their rental dwelling license is up for renewal, and then they would understand when the effective date is. But when you're talking about a tenant acting as a sublessor, they have no idea when the landlord's rental dwelling license is coming up for renewal. So I think that creates a real due process issue there if that's what you're going to base it on.
That's an ordinance that has due process issue.
It's not best practice.
And we would, from an enforcement standpoint, it'd be better to have one date that that date, and it says it in, and everybody knows, and then rather than, okay, it's this address, I gotta look up, what's the license on this, and when do they renew, and all of it, and before we go out. The simpler it is, frankly, the people we're dealing with are humans, the people doing the enforcement were human, and the simpler things are, and the more streamlined they are, the less likely we are to make mistakes and take up unnecessary time. And
it doesn't matter when this enforcement, because you're still enforcing over occupancy.
Yeah.
Law's already there.
Yeah, and that law's already there. You know, because if there's not let's say we go and somebody says, well, I've got a license and there's no over occupancy and, oh, but oops, I'm compliant with everything, but yeah, somehow I missed this disclosure thing. We're going to say, oh, okay, well, yeah, you got time to come in. We'll work with you. We're not going to be going, they're going to have to want a conviction against our will and drag us kicking and screaming into court because they refused to sign a piece of paper.
Adam, you had a question.
Yeah, so I think the point of this is to remove plausible deniability from anyone and expedite the process of bringing people into zoning compliance. I think that's why we need a document for the landlord and for each of the tenants. I think that's what's being said here. What I'm confused about is a suggestion I have made to the council, as well as from the gentleman from the Realtors Group, was to have three conditions upon which effective date and enforcement date would then be acknowledged. The effective date being whatever we choose, which on the books is January 1st, 2018, but an enforcement date being whichever happens first. 1 year from the effective date, the signing of a new lease agreement, or the renewal of a lease agreement. It's easy to sit back and say, we need to punish the people that are opportunistic, be it landlord or tenant, but we need to be mindful of our teachers. And I'm thinking of one specific individual who is a teacher. She has 3 roommates. We have 4 teachers living in the house that 1 to 3 individuals cannot bear the financial burden of. What this would allow them to do is reasonably remove themselves from a financial obligation as they become aware of what true compliance looks like. So we had myself, who's talked throughout the process, and the gentleman from the Realtors Group who suggested those 3 conditions. And by January 1st, 2019, there is no plausible deniability for anybody to be out of compliance. And it doesn't remove teeth, because there are plenty of teeth still in place, but it delays the effect of which this tooth then has an enforcement.
George next.
And that's a huge loophole that would be exploited by the landlord.
For a maximum of 1 year.
Sorry, we put up with this for 6 or 7 years already. I'm not willing to go another year.
Anna?
Just from a neighborhood perspective, where there is a lot of zoning people, and I'm not just talking about me, I'm talking about a lot of people waiting, for this effective date. I know that Cary is going to get hit hard in the next little while with a lot of zoning enforcement. It makes sense to have a single date, because it's just how it's going to be really hard for her to all of a sudden have all of these zoning complaints and go into it without having an ordinance or an effective date in place. I don't know. I also think it's good from administration if maybe there was just not a year, if there even was like a month time frame where you could send out letters to all the owners just to let them get in complaints, so that when all these complaints do come in, I'm saying everyone's kind of on the right foot. That's all I'm saying, is that there are going to be a lot of complaints.
I don't think there's really going to be any more complaints than what we normally get, mainly because we already have in place the over occupancy and other tools. I don't think it's really going to increase it that much. I don't think people will call in and complain and say, I know they don't have their disclosure document, or whatever we end up calling it. I don't think that's going to be an issue. What I do see as being an issue is, and even when we were talking about this and the time frame was becoming closer that it would be passed, I've had management companies contact me, and instead of them going into their files and looking for their rental dwelling license approval letters for their clients, they simply provided us with very long lists of all the properties they manage and want us to provide that information to them, which actually turned out to be very handy, because we found several of the properties, well, more than several, were not licensed. There were some that didn't have addresses that were recognized. And so that's going to be, that in a way, even though it provides us with a lot more work that way, it's still going to be very effective, because we'll be able to see a lot of people that do not have licenses. And in conjunction with this, interestingly enough, I got contacted by a lady who had just purchased a duplex down in Southeast Provo. And she said, well, I need to know what I need to do to comply with this. And can you send me some information? And so I looked up the address she gave me. I said, well, interestingly enough, the people that you purchased it from have never in 12 years had a license. And so you'll have to apply for a license. So, I mean, certainly there are people who do not have licenses. I think that there's probably quite a few. There are some that have interesting addressing that doesn't match our addressing, and so they don't have licenses either. So I think that's where our work is going to come into being more. I don't think that this ordinance really is going to increase the number of complaints that we get for over occupancy or not having a rental license. So.
This will be a good tool to help us in situations where we do believe there is an over occupancy. It'll be a good tool for that. I don't think it will increase the over occupancy reporting. I think Carrie's absolutely right. Where the real work is going to come in is we're going to have management companies, landlords. They have no idea where their license is. Carrie, do you know where yours is right off? Can you tell me?
Yes, it's in my computer, right? Wow.
Yeah.
That's where he knows it is for sure.
I'm sure it's there, and I think I know the drawer.
I'm not sure. You know, and there will be some people, they think they know it, and they'll go and look in that drawer and it's not there, and then rather spend an hour digging through their stuff, they're going to call us.
Yeah.
That's really what's going to happen.
Right. Well, if this is a really big concern about this issue about where people are at in their contracts and fairness, I have two suggestions. One of which you have no control over, but as far as the suggestion that you have control over, I mean, one thing to do. I do agree with Gary and everything that's been said that one single effective and enforcement date is the easiest from an enforcement perspective. It's not the only option, but it's the easiest from an enforcement perspective. But one option you have is picking a date where you think the highest number of contracts are likely not to be in transition, like the end of a semester or, right? So that's one option you have, is trying to pick a date that's less complicated than other dates. As far as the second option, which you don't have control over, but you have some influence over, is that the administration has prosecutorial discretion, right? And in an instance where there is truly a situation that is just patently and obviously unfair, the administration has discretion over how they handle that case. You have influence in the sense that you can send them a message about the fact that you would like them to consider fairness as an issue. You don't have control over what they actually ultimately do. But as an example of that, when we passed a couple of years ago our ordinance prohibiting transfers of property on the roadway, we had an effective date. The effective date was X. The administration said, we're not actually going to ticket anybody for 3 to 4 months after that. What we're going to do is for the first 3 to 4 months, that our police officer is going to go approach the people that they see in violation and tell them, hey, there's this new ordinance and you need to be aware of it, right? And I'm not suggesting necessarily that happened here, but it's up to the administration whether it does or not. But even if there's not a blanket policy, there's at least the opportunity for, when confronted with a situation that kind of common sense would say, oh, it's unfair to kick this person out next week, the administration has the ability to handle that.
Yeah, I like that a lot. I mean, I think my biggest worry is, well, two things. I think the fact that the effective date was January 1st, but no letters were sent out, as I understand it. Correct. I think it makes a lot of sense to say, okay, the effective date is later, March 1st. It has been proposed. The only nervousness I had about March 1st until you spoke was, I just don't want the student to get kicked out of their apartment in the middle of the semester. I think that's unfair to them. And so I like the idea of some sort of leeway that I think I hear you describing, where we can reasonably allow for people to come into compliance if they're out of compliance in the middle of the semester, so that they're able to make alternative arrangements by the summer, or whenever their schedule is.
And if you've listened or with what So that sounded condescending, and I didn't mean it that way. What I meant was referring back
If I was
to.
actually listening.
No, yeah, I'm listening. I'll tell you, that was not what I meant. So
I've read some of this material over and over again. I'm thinking, am I reading?
Brian, should I pat him on the head for you?
So what I meant to say was referring back to what Marcus said earlier. With the March 1st effective date, nobody's going to get prosecuted until after the semester is over anyway, right? Because if we went out on March 1st and started the enforcement process, it'd be mid-May before somebody was actually served with a summons anyway. So,
If not longer.
right.
Yeah, and hopefully it's the landlords chiefly that we're worried about,
Right.
not the tenants anyway.
Right.
That's good. Now we have a question. As we're going, everyone's had a turn virtually. Melanie?
Like most of the problems in my neighborhood are not students. They're young single professionals who are living in the large apartment complexes of Deer Haven, Pioneer, Aspen Summit, Denny Meadows, all these homes that were built with development agreements and restrictive covenants that claimed, now I've got a copy of the restrictive covenants, I sent them to everybody, hope you all got them, that each of these subdivisions require a contract with every tenant. The homeowners association requires that. I've been in contact with the attorney from Pioneer's homeowner association, and he's asked, what is the ordinance and who is the attorney that's enforcing this? So that you're depending all on community development. And I think that simply by having the ordinance in place, adopted, signed, in place, and an attorney that they can call, that you can send a letter out to some of these large homeowners associations and say, this is part of your restrictive covenants, this is part of the city law. Send a letter to every single one of your homeowners, members. And some of the resolution occurs outside of the city and the enforcement things. And having a date and a specific date, an ordinance in place that says this is now in place. It's your responsibility as the agent for the homeowners association to inform your members and know that they can and at this point can be prosecuted. It's going to go a long way. So I don't think we need to necessarily depend on everything that community development is going to do, on every single enforcement action. Just the existence of this ordinance is going, with a date, is going to put pressure on the other entities who are making their living off of the rental real estate business.
Yes, if you're going around, if you're
A question, I'm happy to opine, but otherwise I think you're having a great policy discussion.
does anyone have a question for me? Okay, we really appreciate you having here. I hope you're enjoying it.
You've been awake the whole time.
That's a plus.
That's a plus.
Let's just hit the last item real quick here. Can you pull up, Kelsey, the diagram? I think it's labeled something, the file's labeled something like subleasing disclosures, yeah. So, in the current ordinance, and this applies only to sublease situations, the current ordinance requires that disclosures be signed between the landlord and the sublessees, but not, I mean, those are not the parties that the rental contracts are between. So when I was talking to Mr. McGinn about this a while back, he came up with actually some draft language that of an alternate approach. Could you go down a little bit now? So under this proposed approach, you essentially just require the disclosures between the same parties that are executing the rental agreement. And I'd be interested if your opinion has changed since we talked a month or so ago. But my understanding was you're saying that this would serve just as well for getting the disclosure documents that are needed. And if that's the case, I think this is more efficient and imposes less burden. It's just easier to get it signed at the time you're renewing your rental contract.
I think if you have a tenant and they are now acting as a sublessor and they're subleasing, the same rules ought to apply to them. That because they are a landlord, and they're acting in place of the landlord. So I think it's important to have them in there. I have heard people talk about, well, still have the landlord requirement to the sublessee in this. So an additional, not only to the landlord to the sublessor, but the landlord to the sublessee. That really isn't that important to me either way, but I do think the sublessor and the sublessee ought to be disclosing. If I'm renting and I'm going to invite a bunch of people in, those people that come in, they ought to be notified of what the occupancy is. And the landlord isn't doing it in that situation because they probably don't even know. And so if you've got a tenant and then they're going to act as the sublessor, those sublessees coming in, and often that can be students or other young professionals in that situation. Part of the goal of this ordinance, I think, is to get everybody on the same page of knowing what the occupancy and all of those things are. And to have that requirement in there makes a lot of sense. Because I don't know how a landlord often doesn't even know that there's a sublessee there. They just have no clue. And they wouldn't be violating this ordinance because they would have no clue. And then to come back and now that they know, depending on how their lease is structured and things like that, it may take them quite a while to take care of the landlord, that situation, if they didn't like what was going on with it.
I have just part of me kind of is bothered by this, and we haven't talked about this, but usually someone who's going to subless out is going to do it for a period of time. Let's say somebody has an internship or a job for a short period of time in another state, then I would have a problem locating that person to be able to hold them accountable for not providing that information to their sublessees. So to me, it would make more sense that the landlord would know that there are sublessees there, and it should be the responsibility of the sublessor to provide them with that information. But the landlord should also make sure that they have that information so there's no confliction there. Thoughts?
Yes. And Kelsey, can you scroll back up a little bit to the top? So, well, actually, sorry, I misspoke. Scroll back to the bottom, then I'm going to have you scroll back to the top in a second. So, from the perspective of actually getting the disclosure document in people's hands, I think that I think this is more efficient and simpler and easier for most people. And in a situation where, setting aside Carrie's concern about finding the sublessor, if everybody's trying their best to do their job under the ordinance, I think this is a much simpler situation and easier for everybody. But if you scroll back up to the top, the one slight concern that I have, and the reason why it was originally drafted this way in the first place, is because it was drafted this way because of discussions the committee had about people, and I don't know what percentage of landlords they are. It's probably a very small percentage of landlords. Hence, you've got to think about efficiencies here. But we had discussions in the committee about landlords who we were certain knew about these people, but claimed not to. And we're saying, I don't have any responsibility for this person because I don't know about them. But we knew that they were really telling this person. And the way this would come up is we'd go to the landlord, and the landlord would say, well, I have a lease with one person. That's the only person that I know that's living in the house. And I have no responsibility if there's anybody else in the house, right? And so it was drafted this way to try to address that one situation. And if you scroll back up again, Kelsey, sorry. Gary and I talked about this in a previous meeting, and I think that this proposal probably does, from my perspective, it probably still achieves the same result as far as getting over occupancy out of the house. The problem, though, is it achieves that result by prosecuting this person instead of this person. And so that's the one unintended consequence that you got that you may want to think about is as far as who actually faces the liability. Now, you said something about some have proposed doing both, and so
And just adding the landlord line down to sublessee in that bottom model.
So maybe you solve that problem by doing both, or by putting in a requirement that between these two, that if this person does this, they have to also give a copy to this person, and this person's responsible to. Right, maybe, right. I mean, we could put that requirement into the one-page document. So I think
but the ordinance, I think, would need to be amended to ensure that.
Right.
Yeah.
So I think there's a way to implement this and still solve the above, but there's some complications between either going strictly one way or the other.
Okay, so we have 1, 2, Melanie again.
Well, I remember during the dwelling license discussions, it was very adamant that the person making the profit be the person who bears the responsibility. When you've got people who are consumers being held responsible for the money that the landlord is making, that's not fair. That was always the discussion. The person making the money is the one who bears the responsibility. That's not the sublessor.
It could be, though, but it could be.
Well,
because we've had landlords get up and say, I mean, I just said that we've had landlords say that they didn't know anything about it when we're sure that they did. But I'm sure that there are also instances where the landlord really didn't know anything about it and was actually being an active, good landlord and wanted to know about it, and the sublessor / tenant was hiding it from them.
Or did know about it and was doing everything they could to resolve it, but had resistance from the tenants. Not so, but there is.
And sometimes that sublessor is the one making the profit.
So in this last model,
no, they're not making the profit. I don't think that's the case.
Well, it could be because they could enter into a lease for $800, and then they can have 4 roommates that are paying them $400 a piece.
Do it all the time.
Hitting that sucker to the wall.
This last thing we've talked about, I like the fact that the sublessor would be responsible to provide the disclosure and acknowledgement, and we do want people informed and educated. But one of those people that needs to be informed under all circumstances is the landlord. So as long as we can work it back around so he gets a copy of the relevant information so he can't as easily plead ignorance, that would be appreciated. Dave?
This is important enough. I have no problem going past noon. I don't know what other people's schedules are, but I really would like a little bit of time to talk about the proposal.
Okay, so, and we're just about done with what you've got, and Adam, yes, you have something?
I find myself in the bottom situation where I have my subleasees come and go. One of them had medical issues, but I don't think that I should have to lose the privacy of my legal occupation. If we have some kind of disclosure that filters back to the landlord, then I then face the scrutiny of my landlord for my life decisions. I realize it makes it easier for enforcement, but I don't think that I should lose the privacy of my legal occupation through a contract and or through ordinance and zoning.
I think you get that anyway when you lease. I think you give up some of those things anyway.
Currently, I don't.
Well, I think in general you do.
So
I think you do. It's not your house. So I think you give up some
during the
things.
lease period, it is my house.
No.
But I guess my response to that, Adam, would be, and I could postulate a situation that's different, but if you have a landlord, because you're a lessee, right? If you have a landlord who doesn't care enough about who's there that he'll allow you to sublease, because he doesn't have to allow you to sublease.
He cares enough and trusts enough for me.
So if he's that kind of person, then how likely is it that he's going to judge you for who the sublessees are?
If I choose to move my girlfriend in, as opposed to another male roommate, then there's potential scrutiny here. Am I going to do that? Probably not. But again, it encumbers me with privacy disclosures as well as just additional paperwork.
Okay, so time for Dave Harding.
Can we keep that visual still up?
Yeah, perfect.
and just center this on the whiteboard. All right. I've tried to keep my comments to a minimum. There is one question I have before I jump into this. We talked about the RDLs, and a question that's come up that I've heard someone make a comment about, that there's a lot of rentals in Provo that don't have RDLs currently. And I wanted to know what community development's take is on. Is that true that we have, what percentage would you guess of?
Well, we have a great deal of properties that do have rental dwelling license, but obviously getting a list and finding out that some of them under a management company don't have a rental license. Sometimes what happens is property sells, the new owner fails to get a license. Or like that one, just, the law's been in effect since 2003. Certainly there's going to be some people who are oblivious or just didn't do it, but I don't know number-wise.
I doubt there are too many new apartments that we don't know about.
Right.
But so one may have been licensed for 5 years and it sold, the new owner didn't get a license and we didn't know that. And so they don't currently have a license. And that number, my guess is, and this is just a wild guess, is probably, a few hundred maybe.
Is that 10%? Is that 5%? 15%?
Oh, it'd be under 1%. There's probably 17,000 apartments in the city.
Okay. And you're just talking a few hundred.
Few hundred.
So single digit percentage. And do we think that's growing since implementation or shrinking?
Probably slightly growing, just as you have turnover.
Okay. And if I remember correctly, we had like 12 or so zoning officers when this first came in, because we knew we would need some effort to enforce and get people onto the
to get licensed and to do all the research necessary to appropriate license things. We had to have a lot of people.
Okay. And I heard earlier you said that, because of these people contacting you with lists, I'm just curious, just speaking as a council, or, to the council, do you feel like you need more officers in order to be able to cope with that increased workload before?
I don't think so.
Don't think so. Okay. All right. So I have been trying to kind of keep quiet a little bit, listening to the
and
discussion.
actually, Carrie and I may have a disagreement on that. I think we may, but I'm not willing right now to say, yes, we need X number more.
Okay. But that may be something in the future. And as we go into budgeting and whatnot, I think we've made it a high priority, and we're now maybe hitting the point where the rubber's meeting the road, and I think you'd probably find that we'd be interested in giving you that additional support if it's needed. Okay, so try to keep quiet as much as I could. I have there's this proposal, and I'm really excited about it. And to me, like every time someone brings up a concern, well, what about this? What about this? I'm like, oh, this addresses it. This addresses it. This addresses it. I'm really excited about it. To me, it's super simple and it's super straightforward and it's elegant and it's all that thing. I've also tried to explain it a few times, and it seems like people don't understand. They have questions. I must be just really failing at explaining. So I will try to go as quickly as possible, but here, love to answer questions or whatnot. And in some ways, I think we've been heading in that direction anyway. So the proposal is, and I already turned this off. I'd either try to do it by memory or just kind of follow along. So basically, this splits it into two parts. Okay, the first part proposes that all individuals renting out property, entering into a lease agreement, either written or verbal, are required to disclose to the tenants their rights and responsibilities at the time of agreement. So basically, we're saying that this disclosure and acknowledgement is required at the time of lease agreement. Anytime there's a rental. Okay. Oh no, sorry. Scroll up. Or bring it. Yep. Oh yes. Okay. This is required. This is required. This is required. Okay. Both parties should keep the signed copies of the disclosure. Knowing failure to disclose would be punishable by a civil fine that would start small and would increase with each offense. Landlords and their agents are required, as well as lessees and leaseholders and subleasees. This could go into effect immediately, okay? Because it needs to be knowingly. You know, the infraction would be knowingly entering into a rental contract or lease agreement without disclosing would be a violation of this. And the RDL process, it may take some time. We're updating this now, so it may be a couple months or whatever, but as part of the RDL process, someone who's getting an RDL would need to acknowledge that they understand that this is a requirement. So at any point, if there is a rental agreement that's entered into that they did not disclose after acknowledging that they understand it, there's no 30 days to come into compliance. It is just fine. And that first fine, whatever it is, maybe it's $30, maybe it's $100, whatever, but there's a small fine that says, you said you knew about this and you did not disclose, therefore, here's your fine. Leasee gets their rights and responsibilities, and one of the rights and responsibilities there is if you sublease, by law, you have to give this same, you have to disclose these same rights and responsibilities to your subleasee. So if a subleasee, you know, or if a sublessor subleases, and if they do not do this disclosure after they signed this one, they get a fine. And if they do it again, or if the landlord does it again and again and again, the fines just go up, okay? But the point of this is to try to get this rights and responsibilities, try to inform, educate everyone, and as quickly as possible and as broadly as possible. And compared to this, where we're asking landlords to sign us with the subleasees, that can be quite a burden. And if we say, you know, even if it's March 1st, we're now asking landlords or the management companies to go out to every single adult tenant across the city and have them sign a sheet by whenever the date is. Is that a little bit unreasonable? We've had responses, well, what happens is there'll be a complaint and then we'll go in, we'll give them 30 days and they can do that. But if that's how it's enforced, then people, why would they go out and spend a couple of weeks running to 40 different apartments to get people to sign stuff when they can just wait until enforcement starts and then come into compliance? So this is saying you have to sign this, or you have to have this signed at the time, or you will get your fine. And so, and they have, you know, they've acknowledged that they understand that it is a requirement. So anyway, so that's the first half, okay? And as far, if we go back to, well, okay, let me explain the second half. The second half is inspired by Dave Decker's proposed solution about the 90 gallons, how it's probably not necessary for most of the instances, but it's nice to have a hard number when you go to do the actual enforcement. Same thing here. Instead of saying everyone has to have a written rental contract between landlord and subleasee, we give community development the ability to require it. They may require this. Let me see. Yeah, so really all it is community development has the ability to require written lease agreements or written contracts between the landlord and each adult tenant.
Well, I mean, as long as they have the ability to appeal that decision, there's probably not a due process issue, and I'm not sure how that's any different than our first version of the ordinance that actually required a written lease agreement in every rental situation. The question I guess I have, Dave, and maybe you're just getting to this, is I had the same thought when we were talking about the administrative burden of implementing this, but my thought when I first thought about it, my thought had been, well, what if we don't require the disclosure at all? And the only requirement is that after zoning enforcement has gone out to address a complaint, and then the director has this ability. So I guess my question under your scenario is, if part one is requiring the disclosure in all instances, what's the purpose of part two? Why would the director ever require such an agreement?
Okay, perfect. Okay, so let me just draw this here. So the green is what they may do, and call this written rental contract. Okay, and I'll leave that for now, but I'll come back to that. So the reason why this would happen is, as was pointed out, called earlier, the plausible deniability, or the scenario where the landlord says, look, I have a contract with one person. I've disclosed to them. What they do beyond that, I don't know. And so it shifts all of the burden from the landlord to the sublessor. Who does the city have a contract or have a relationship with? We have a relationship with the landlord through the RDL. Who's permanent and who's transitory? If you have someone that's willing, I don't care if the city threatens me, because at the end of the semester, I'll just move to Orem, or I'll just move somewhere else. They don't, where the landlord, if they're having a hard time, well, their option is to sell and buy somewhere else. This person is much more permanent, and that's the reason why it's easy for them to push it off onto the sublessor and shift that responsibility away and keep it at arm's length. This shifts the responsibility back to the landlord, and the landlord can't do it. So what this would look like, a complaint comes in, they knock on the door and said, we have a complaint that there's over occupancy. The person behind the door says, I don't want to talk to you, shuts the door. Okay, so they go to the landlord and say, landlord, we feel that there's been a complaint of over occupancy. There's reasonable cause to believe this. And the landlord says, I've got a contract with one person. I'm not doing anything wrong. Go take it up with them. So you're getting, I think the word, the cooperative, the plea and abeyance, they need to be cooperative. If people are being cooperative, then you never have to do this. This is only when people are evasive, they're not cooperating, then it says, okay, well, you now have 30 days. We're not going to require a written rental contract from you, and you have 30 days to come into compliance. And so it's the same tool that we have in version 2 that's currently the law, but instead of being applied to 100% of the renters across Provo, instead of having this burden on every single person, you only have the burden on people that are uncooperative. If you've got a good acting landlord and a bad acting subleasor, the landlord says, oh yeah, I'll help you, and this is where I'm getting outside of my knowledge, but I assume the landlord can say, I'll let you do an inspection. Let's work together, let's see if we can do this. If you have a good acting sublessor, or just a naive, not the right word, but someone that doesn't know what the law is.
Well-intended.
But sorry, say again.
Well-intended.
A well-intended, but over-occupying sublessor, and it's the landlord. Then the sublessor is going to let you in and walk through and show you, okay, yeah, we actually do have 4 people. I didn't know that was a problem. So this only happens when you don't get compliance. And now it's a way to make it so the landlord can't push it off on someone else and let them go through the process for 2 more months, and then they just move to a different place, because again, they're the permanent one. I should say, I would have no problem changing this from a written rental contract to be a disclosure and acknowledgement. So it's exactly the same as this. The only difference is we tie these 2 together. I have no problem with that. I've just heard from some people that are saying, boy, we really would like to have a written contract. That we feel like that would help us with enforcement. I don't know. And if that's not desired, I have no problem doing this. So no contracts are required anywhere. It's just disclosure between them. But if we're having problems with cooperation, and you require the disclosure and agreement with all adults. I don't care which way that goes. But again, the point is by requiring this at the time and not giving people 30 days to come into compliance, I think you get a lot more compliance. This happens much more often because people can't just say, I'll take care of it when they start enforcement. And the burden is much less because it only happens when they're signing papers anyway, when the lease agreement happens. And we're only more, privacy and intrusive and whatnot. That only happens when you're not getting cooperation.
Something I'd like to understand a little bit better is, what do you mean not getting cooperation? Because people are obviously under no obligation to incriminate themselves, and so if we are imposing some sort of penalty, if you will, or some sort of additional requirement because they're exercising their rights to remain silent, there probably are some constitutional issues with that.
Okay. Just uncooperative is just words that I've heard from.
Right. So that's why I would like some further clarification what you mean by uncooperative. I mean, if they just simply say, no, I'm not going to talk to you. Well, they have every constitutional right to remain silent.
Okay. Then you go to the landlord, and the landlord.
Right, and he has constitutional right to remain silent.
Okay.
So
if we've established probable cause, is that the point where you get the warrant?
That's the point where you can get a warrant.
You have to get a warrant, though.
And then you could compel cooperation with a warrant. So I do have some concerns about that. I mean, I guess under your proposed scenario, it's only going to be a civil issue. But again, that raises those same issues I raised earlier, that it actually provides less protection to the citizens because there's fewer due process rights associated in a civil case than a criminal.
And that phase one, that's one thing I would suggest to the committee to take a look at further. This ordinance was drafted under the premise that we'd be doing enforcement the way we're doing it currently through justice court.
Correct.
Now, we do have Title 17 administrative citations where you can get a daily fine. It's like you get a ticket. Do you have your disclosure? No, here's your ticket. And it's a $25 fine. And then you can have escalation. We have that in ordinance. And it's really not that you need a new ordinance, it's that we need to approach our enforcement in that way. And I think that's part of what the council probably ought to talk about is, do you want the city to do some enforcement of certain types of ordinances in that way with daily fines? Now, West Valley tends to use that quite a bit, and people will really accrue high levels of fines. And then they've made it, in the past, it didn't work very well because the collecting fines that were assessed was under finances, the finance department's ability, and they didn't really have any people doing it, and they didn't send it out to collection agencies to get it done, and so it just didn't work well. But if that's a high priority of the council, that type of approach is something that you could look at, and our ordinances already take that into account.
David, I appreciate your effort. We have a zoning committee that spent 6-7 months, almost a year on this. I don't think your proposal is better than what we've come up with personally.
Okay.
I think it introduces a whole bunch of new issues, how we have to change the way we enforce versus how we do it today. I don't know why we would want to do this. I don't think we're putting an undue burden on landlords to inform residents of their rights and also to inform them what is legal and not legal in the rentals. That's not a burden. I mean, I don't understand why you think it's such a huge burden.
Between now and March 1st, they have to go out and get signed papers for every single person that they rent to. Versus, you have to inform them, it has to be signed, but it has to be signed at time of contract.
Anytime you have something where people aren't required to do something, you're not going to have the compliance that we will get less compliance under this way than we would the other way.
But you are requiring it. You're requiring it at time of lease agreement. It's absolutely required. The way I see that the fine would not be a daily thing, because the fine is you entered into an agreement without signing, without disclosing.
Yeah,
so it's a one-time.
It doesn't have to be a daily thing.
And everything, all the other stuff if it's over occupancy or whatever the zoning violation that caused the complaint, that is still prosecuted under the same method as it always has. But in addition to that, if they have not signed, if they did not disclose at time of agreement, here's a fine.
And that's something that we need to really sit down, because kind of one transaction or one situation, you might have several offenses in there. And we're talking about taking some to justice court and then some through an administrative process, and there may be some problems with that.
It does definitely complicate matters. I mean, especially, my understanding of the purpose behind the ordinance to help us enforce on over-occupancy situations by providing a way, an indirect measure to enforce on that. So it would certainly complicate matters if you do have evidence of other violations that are uncovered during the investigation, whether it be a no RDL, whether it be that you're able to develop proof of the underlying over-occupancy, or if there's something else to be taking, I guess, a multifaceted approach by we're going to criminally prosecute these, we're going to civil fines on these, and it certainly, I think, complicates matters, and we definitely would want to look at that pretty thoroughly rather than, I guess, coming in.
I wanted to simplify. Now we're making it more complicated.
First, before you, Brian, Neil?
I would like to comment on this. I think there's a problem of vagueness potential, and what's uncooperative under the ordinance, and when does the city force two parties to enter into an agreement? It could be pretty arbitrary as to what uncooperative means. And you might have an equal protection issue there, because you're delegating to the staff some authority that's not clear in the ordinance. You have to define uncooperative very explicitly and definitely in the ordinance to give the administrative people guidance as to when the contract would be required or not. And I think that's going to be a very difficult task to do.
Okay. And if this helps,
well, call it the other thing. I don't think the label matters. It's still, when's it going to be required, under what circumstances, what factual circumstances. Whereas under the present ordinance, there's a clear line. Everybody in the situation of renting property has to follow a certain rule.
Okay. Brian, then Melanie.
Well, okay, I'm going to take a little bit of a different take on it than a couple of the comments in kind of a collaborative spirit. In some ways, I see this proposal almost being the same as everything that we just talked about. In this way, that if the council's intent is to pull back from, is to go with the idea that's been suggested, that we come up with one sheet of paper, that we require that sheet of paper to be exchanged between everybody, then that's already in here, right? And there's no difference between those two. They're complementary. And then as far as your the part of the proposal that is under certain circumstances, there's no delay in enforcement because we absolutely are sure that it's a knowing violation. I think I actually really like that. But that doesn't necessarily need to be part of the ordinance. That can be just part of the administration talking about how are we going to do enforcement, and in those, and we come up with a list of criteria that say, yeah, we can check. Did they check the box? Have they renewed their license since last time since this ordinance was passed? And if so, we're not going to give them a notice of violation. We're just going to send them a summons. So in that way, I think they mesh well and are very complementary.
And I agree with that. The only thing would be is if we want a $25 fine because they didn't do that, we may have to do something different.
And I was going to say probably the only part of the proposal, maybe, and hopefully this is constructive criticism, but I think the only part of the proposal that I don't like is restricting the penalty to civil, to civil only. I think that from enforcement perspective, it's much better to have those who are enforcing have options, and for a criminal penalty to be on the table, but for the administration and those who are doing the enforcement to sit down and weigh their options and say what's most effective. And if we think civil fines and civil notification is more effective, then in this particular instance than in other particular instances, we'll go back to doing that. We'll try it for a while and see how effective it is. And as Gary has suggested, if the committee sits down and talks about specifically how to achieve enforcement here, and that's the way that they want to go, I think that's a perfectly acceptable solution. But as to this last issue about the ability to require the agreements, I share some of Neil and Marcus's concerns, but I think that it's a concept that we could use with more discussion, because if the council decides to go with this model that Mr. Sewell has proposed of having the disclosure by default only being required between the sublessor and the sublessee and not between the landlord and the sublessee, I think it's possible that we could use the concept you've taken. I think we need to flesh it out some more, and I don't have it firmly in my head, but I think we could develop some criteria that say if that's failed because a sublessee cannot furnish the disclosure and says I never got one, and we can't track the sublessor down, then in those circumstances we can require the landlord to provide the disclosure to the sublessee. To the sublessee if the sublessor is missing. If the sublessor is out of the picture, they're on vacation in Europe for a year.
And as I heard your proposal, what I was thinking is do this bottom model, but add in the lines from the landlord to the sublessee. And then as Brian talked earlier about prosecutorial discretion, what we're doing, frankly, we would go in and the most likely person to be there is the sublessor. They may be gone or something in that situation. Then if we can't, then we would go to the landlord at that situation. And that would be really up to us, that we would try to be enforcing it in the most sensible way we could. And if we can't get any, people are living there, there's no sublessor, nobody seems to know what's going on, then we would go to the landlord and say, hey, you've got this requirement. The landlord may say, well, I'm only doing it with this one person, and then we run into different things. And at that point, it may be, this ordinance really isn't helping us. This is one of these bigger ones that we're just going to do a good old-fashioned civil lawsuit against the landlord, so we got problems. But that's something we'd have to sit down and really think about and go through.
Yeah, this proposal was intentionally high level without the details. And as I said, our discussion, I think, has moved us in this direction anyway. So that this concept of passing the disclosures up to the landlord, I hadn't considered that. I think that's definitely kind of gets to the same idea here. The one thing I do want, whether however the details are worked out, I do feel that a change on how we enforce on the disclosure and acknowledgement is important. If you tell people, we tell people all the time, our standard practice is if we find that you're out of compliance, we give you 30 days to come into compliance. I don't think that should apply for these disclosure and acknowledgements. They have to be done at the time of the agreement in order to be effectual. The whole point is to educate people, to inform them of what their rights and responsibilities are. That has to be done at the beginning. And so as long as we're treating these as, it seems to be pretty cut and dry. You go to the sublessor, do you have this? Oh, I don't know what you're talking about. I never got one. You go to the landlord and he says, no, actually it's right here. There's their signature. We say, okay, we're good. If neither can supply it, okay, here's your $25, $50 fine, whatever. And when you do this again, it's going to be $125. But whatever it is, I think these should be treated differently. Otherwise, you're just going to have people that will be out of compliance until you do enforcement. And we can't enforce on 17,000 apartments. We're going to be doing them 300 a year or whatever, and we're never going to get there. But if we have something that people fear the enforcement because they can't come into compliance, it was done at the right time, or I get a fine, then they're going to be motivated to do it.
Okay, I'd like to make a motion. One final comment? No? Okay.
I make a motion that we delay the implementation date to March 1 and instruct staff to come up to the zoning committee with a new recommendation of what the ordinance should look like, working between our staff and community development, and then we can review it and send it on to the council. But we would need to, the other ordinance would be implemented March 1 unless we make a change before then, which I assume we have 4 council meetings.
So just strictly from a, technical and separation of powers aspect, I think that that's fine and doable with the administration's cooperation, right? Because we have an ordinance that's actually on the books and says it has an effective date right now. So what I interpret the motion to be is that the council is actually asking the administration to not do any enforcement of that ordinance until March 1st. And as long as the administration is fine with that, I don't think you need to take any steps to amend or repeal that ordinance while you're figuring out the.
And we're not going to send any letters or do anything until we get the final version that everybody feels comfortable with.
So if Mr. Council is agreeable with that, that's fine. I'll change my motion to that.
Just a point of clarification, we are planning on putting an agenda item on the 9th to amend or repeal. So we could.
Well, I guess the question.
I would ask that we not do that. My motion would be that we not do that.
Because that's the question, is whether that's still necessary or not. If there's a motion that the council's intent is, or expectation or hope is that no enforcement happened before March 1st, and the administration has expressed,
and we won't,
they're not going to do that, then I don't think it's vital that you take action on the 9th.
But
It's up to
then
the
what's
council to
what's
decide.
the point of, the point of the delay is to iron out these kinks, right? And we call that an amendment or not? So
So it would be amended, but it wouldn't be amended until you had the actual changes.
But I thought what George, in his motion, he wanted those proposed changes to go to the zoning committee first and then come to the council. Once the zoning committee.
I would have, they could come to the council if they went directly, I don't care.
Oh,
but it seems like it would be nice to have it come to the zoning committee because we get administrative input. We get Marcus from you, from Carrie. I think it would be nice to have it come to the zoning committee first.
Clarification, is that a motion to the planning committee, zoning committee, or is that the proposal to the council?
To the council, the zoning committee doesn't exist. This is the council session.
Okay. So let me just talk out loud real quick. So if we leave it effective and just ask the administration to fix it or not enforce it until March 1st, and then the default is if no agreement can be made, then it's effective March 1st. If we were, say, to repeal on the 9th, now we've got, until March 1st to come to an agreement.
I think we send a message that we shouldn't send to the neighborhoods when we repeal it. An expectation is we're not going to have it. If we have something there already, then it puts us in a position of having to make those changes by March 1.
I'll second your motion.
Dave, I will take that you want to say, I get one comment.
Okay, one last comment, Melanie.
Well, in the past, when there has been a more adversarial relationship between the administration and the council, it was made very clear to me, at least I thought, that the council can't give any directions to any member of the administration. That you can ask all you want to, but that the way that the council gives its intention of what it wants, and also and requires the administration to act, is by passing the ordinance and leaving it in place. You're doing some things here that at some point could have in the past been challenged by other administrations and other councils, right?
Well, I don't think so, because I don't think they are giving instruction. I was trying to make that clear in my comment that by doing that, you are relying upon the administration's acquiescence to your expressed intent.
Yes.
Right?
We have no intention of sending out any letters to landlords about the current ordinance as it exists now with its enactment date of January 1. We're going to wait and see what the council does with a new ordinance. So let's say the council gets it.
When they pass it, then what will you do?
Then we'll send out letters and get moving on that. If the council comes back and at some point can't come up with a new ordinance, but yet there's still this current ordinance on the books, then as an administration, we'll say, okay, the council didn't make any changes. This is what we're going to have for the foreseeable future. Okay, we'll come down, we'll send out letters, we'll pick a date that will tell people, oh, by the way, we're going to start enforcing this on this day.
If this ordinance has already passed and adopted, why haven't you already done? And the effective date was January 1. Why hasn't that already been done?
Because
it's January 3rd.
Because it's January 3rd. We didn't do it during the interim. It wasn't, Mayor Curtis resigned. It didn't get signed. It doesn't come into, when was the effective date that it would have been technically effective?
Out December 17th or something like that would have been when it would have gone into law, but it still would not have been effective until January 1st.
So it would have gone into law not until December 17th. We determined that we couldn't get notification out to people in enough time to make it.
That was not discretion by your staff. That was just because of the administrative glitches, the changes of administration.
Well, no, we could have sent letters out. We could be out there saying, you have to have this today, but we just didn't think it was fair to do that to people. So we didn't send the letters out. And the ordinance doesn't require letters. That's just something that the administrations do. Yeah, we could go out today and start enforcing this ordinance, but we're not going to do that if the council, if we think there's a reasonable likelihood that the council will amend this ordinance.
Okay, I think we're done with that. Can I just clarify? So during the period when I was acting mayor for 3 weeks, it was my understanding that 5 of the incoming elected officials wanted to see some changes. And so I did have discussion with community development. They would probably be better not to send them out. And I believe that was your feeling as well. And my understanding was that the incoming mayor had the same feeling. So that's.
Thank you.
Yeah. So what I'm suggesting is that the council has 2 options, and there's pros and cons to both of them. One option is to say we don't want to have to trust in whether the administration will or won't enforce the ordinance. We don't want to have to even think about what they're going to do, and we aren't concerned about any message that it might send to those who are or are not worried about enforcement by repealing. And so there's certainly one option, and it's a clean option, is to on January 9th repeal the ordinance and say the ordinance is no longer in effect, it's no longer on the books, it doesn't exist until a new ordinance is passed. And you can do that, and that's a perfectly valid choice. The other option that I'm suggesting is that if there's agreement among the council that that the council as a body is not desiring or expecting or asking the administration to start enforcement immediately or until March 1st, and the council has confidence that the administration is in agreement with that concept, you don't have to repeal it. And the I think the cons are probably self-evident from the way I just stated that. The pros are that you don't then have to have an additional hearing on the item immediately while there's a lot of discussion taking place about what the substitute proposal is and exactly what the concrete details of the substitute proposal are supposed to be. You don't have to, there's maybe some PR benefits to not having that. And some council members have expressed that they think that doing the repeal sends a signal, or may send a signal to some, that enforcement is not actually intended. So, either one of those is fine. It's just up to the council to decide which one of those 2 they want to go with.
We have a motion and a second. And more comments, more discussion.
Well, I'm inclined to get some sort of assurance from administration that they, I guess the only relevant person who's not here is the mayor, right? But if we have some assurance that no action is going to be taken on it, I don't see. I would worry that a repeal would be too disruptive, and I think the intent to amend has to be clearly stated here. And as long as we have that assurance that There's no actions
Department
gonna go
director can
forward.
give that assurance.
What's that?
The department director can give that assurance that he has.
Okay.
Having been a mayor, if my department director made those assurances, I would honor those assurances.
Well,
I think the mayor's-
do you know if the mayor's coming to
She's there
leadership
anyway.
tomorrow?
She's there anyway.
That's where she is.
I'm not sure. My preference would be to still have the agenda item on the meeting and on the public meeting for 2 reasons. One, we have a council member who's not here right now. 3 of us haven't been sworn in yet, and you mentioned that we're not supposed to take any official actions, and this is starting to feel like we're inching toward making an official decision here that's sort of binding. So I would like to digest the discussion here and make the decision that's being proposed, either in the work meeting or in the public meeting. Mr. Hart.
One point of discussion on the proposal. I'm very sensitive to your concern about the message that we're sending. I think if we repeal, that could, we can be as clear as we can that this is just a temporary repeal until we work out some details. But the message, I understand that, the message might be, we're not serious about that. If we don't repeal, one of our major concerns is we have these occupancy regulations, and we feel that even when people know about them, they're choosing to disregard them, and that's part of that social expectation. It doesn't really matter. It's not really enforced. No one really cares. There's no consequences. And now we're saying, well, we're going to have this law on the books, and now, I don't know how many people have signed these things already, but if we have 17,000 rentals, it would surprise me if we have more than 16,500 that aren't out of compliance right this moment, and we're going to say, it's okay, we're not going to enforce. Don't worry about it. We'll worry about that later. So we're okay with them being out of
It
compliance.
doesn't seem like there's any way to fix that, right?
Well,
The repeal would do that.
Well, there's
They would no longer be out of
But you
compliance.
still create the same problem that you were just talking about. You still create the impression that we're not serious about enforcement.
There's another
So-
option, which is that in the January 9th meeting, rather than appealing, you could formally amend the effective date of the ordinance so that it's still on the books. It hasn't been repealed, but you have actually formally changed the date instead of changing the date by agreement.
So if we leave it on the agenda, we can just decide at that time to amend it and extend it.
Mentioned it don't say it's for repeal, but it's to amend the effective date. I can vote for that. Would you clarify then what I missed, what my motion would be?
Sure. So as I understand it, at the current moment, Mr. Stewart's motion would be to leave the agenda item on, or to put an agenda item on for the January 9th meeting, limiting that agenda item to amending the current version of the ordinance with the intent of amending the effective date. And that and then between now and whenever that new effective date is, that additionally, staff, council staff and community development staff will work together to bring back to first the zoning committee and then to the full council a proposal for changes and amendments to the ordinance.
That answers your question, Dave.
And the only thing could I add to that, with a request to the administration not to enforce.
Right.
Between now and the 9th.
Between now and the 9th.
Oh, okay, between now and the 9th. Okay, got it.
Okay, I second that. Ready to vote? I don't want to push it, but I've got to be somewhere at 12:30.
Yeah, I've got to be somewhere too, but again, I'm not comfortable with that. I couldn't vote for it because I feel like the repeal option needs to remain on the table for discussion. I think this decision that we're making needs to be made with Mr. Van Buren and with the mayor present and part of the discussion. So is putting something on the agenda, is that an official action? I mean, can the three of us even vote on this?
Yeah, I mean, essentially, and again, here's a philosophical discussion. There's no penalty for you actually passing an ordinance if you haven't taken the oath of office. The state statute says you shall take the oath of office before entering upon your duties, but there's no remedy if you don't. Okay, so it doesn't affect anything if you don't.
There's no enforcement.
You may get a nasty letter. I guess you could get a nasty letter from the lieutenant governor's office, but it's not going to invalidate an action. Okay. first of all. But second of all, I don't interpret that as being, as being that kind of action. I would say that applies to actually implementing ordinances and passing legislation. That's something else I'm gonna say, but I lost my train of thought.
Are we ready for a vote?
I'm going to abstain just because of these questions. I don't think we necessarily need a motion to do this. I think the chair can direct it to happen. I'm okay with the vote. I'm just the position that I'm in, I'm going to abstain.
And I will say, so again, this is lack of clarity on perhaps on state ordinance, but while there is a statute that says your oath of office, that you should take the oath of office before entering among your duties, there's another statute that says your term begins at noon on Monday. So your term has begun and you are an elected official, whether you've taken the oath of office or not.
The other thing we talked about, Brian and I talked about, was that anything you decide right now is really just directional as opposed to adopting something of substance.
Yeah, so that's what's confusing me. Sorry, I feel like, am I voting now on whether I want to repeal it? No, I don't want to repeal it. Are we voting now because we're just deciding whether or not it stays on the agenda for Tuesday as it is?
So the chair has the right, as the chair, to put something on the agenda. And he is intending at this point, as I understand it, to put on a repeal or replace or whatever.
Let me clarify that.
Yeah.
Unless I'm directed right now by 4 or more council members to the contrary, I will put an agenda item on that says amend or repeal. So leave maximum flexibility.
So your motion is actually.
And the alternative would be what?
Well, so the alternative is that I think Mr. Stewart's motion, if it passes, would be exactly that, in my view, would be direction that the agenda item only allow an amendment and not allow a repeal. Now, whether this is too much of a compromise position or not, I'll point out that if on January 9th you amend it to have an effective date of March 1st, it is not in effect until then, and it could be repealed at any point prior to that.
Anyway.
Exactly.
I'm going to abstain for the same reasons as Mr. Hardy.
David?
Okay, are we ready to vote? Yes?
Tell me again what we're voting.
Give me the words here that we're doing. So I make sure I know what I've got working on here.
So all that the motion accomplishes is, it accomplishes 2 things. One, it directs staff to work on the tweaks that have been discussed in this and bring a new version of the ordinance to the zoning committee. It also.
And then to the council.
And then to the council. It also directs staff to place on the agenda for the January 9th meeting an agenda item to consider the amendment of the already passed ordinance. The stated intent of that amendment is to change the effective date, but it has explicitly not directing staff to include the option to repeal the ordinance on January. Did that answer your question? Is that clear enough?
Okay, so all those in favor of the motion? And those opposed? Or abstaining? Okay, 2 abstentions. Dave Harding, Dave Sewell, abstaining. This meeting is now adjourned, I believe. Thank you for coming.
Yes.